The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Well, good morning, everybody. Welcome to our virtual Court of Appeals this morning. I appreciate everyone's patience and willingness to work through some of the technical difficulties as we get started this morning. I am Toby Hansen. I'll be head of panel today. By way of introduction, I want to extend a very warm welcome to the bench, to this court. To my colleagues. On my virtual right is Judge Jeff Carpenter. On my virtual left is Judge Garen Jackson. Gentlemen, I look forward to working and serving with both of you in this role, and excited to serve on this panel with both of you. With that, we do have one case for argument this morning. It's COA 20-399. Miller, the Carolina Coast Emergency Physicians, etc. et al. I believe we have an understanding amongst the parties how they're going to split the time, and so unless there are any concerns, Ms. Shields, are you ready to proceed on behalf of the appellant?
I am, Your Honor. Thank you.
Great.
Good morning, everyone. May it please the court. I'm Patricia Shields. I'm here today appearing for the plaintiff. I would like to take just a few seconds of my very precious 30 minutes to say what an honor it is to be here today and to be the very first lawyer to appear before Judges Jackson and Carpenter in their role as Court of Appeals judges. I'd like to reserve 5 minutes for rebuttal. There are many issues in this case. We have 11 briefs. And so I'm going to be, and there's a lot to unpack. I'm going to be brief in the statement of the facts. Briefly, this is a medical malpractice action that arose out of the death of Mr. Larry Miller in March of 2010. Mr. Miller and his wife went to the Betsy Johnson Memorial Hospital, which is owned by Harnett Health, on March the 8th. Mr. Miller had not urinated for 3 days. And the evidence is that basic medical assessments and evaluations that were required by the standard of care were not done. This includes not even doing any blood work. Dr. Rayner was his treating physician. He prescribed antibiotics, had a Foley catheter inserted, and Mr. Miller was sent home. The next day, Mr. Miller returned, and still the basic assessments, the basic treatments were not given. Specifically, for example, by way of example, oxygen was not provided, IV fluids were not provided. The evidence is that had those things happened, Mr. Miller would have survived, but he did not. In the presence of his wife, he died at Betsy Johnson Hospital. The primary cause of his death was sepsis, and the testimony and evidence of the experts attended to a completely avoidable result. His first medical malpractice action was filed in September of 2011. There were claims made against Dr. Rayner and his practice, and I'll collectively refer to those defendants as Dr. Rayner. And there were claims against Harnett Health, which operates Betsy Johnson. 2 theories were alleged against Harnett Health. One was the negligence of the nurses. Second was the negligence of Dr. Rayner as an apparent agent of the hospital. This is in paragraph 75 of both the original and refiled complaints. There was a voluntary dismissal taken of the original action. In 2014, the case was refiled with identical claims. As I mentioned, there are many, many issues on this appeal. Fortunately, all of those issues are controlled either by statute or clear precedent from this court and the Supreme Court.
Ms. Shields, can you, one thing as we start jumping into the argument, obviously the initial complaint was filed 1 day before the effective date of the more current version of what we'll call Rule 9J. And then the amended complaint, or the second complaint filed in around 2014, I think. Is there any dispute amongst the parties as to which version of Rule 9J is applicable to this action? In other words, did the filing of the 2014 complaint, does that essentially relate back to the prior version of the statute?
Your Honor, I don't think there's a dispute about that. I think that mostly because it's a distinction without a difference here. The original review before the first complaint was filed complied with the standard that was later enacted. Obviously, the standard of reviewing all medical records didn't apply to the first complaint, but all pertinent medical records were reviewed before the first complaint was filed, and they were all reviewed before the second was filed as well. So it's really an academic question in this particular case. Your Honors, my plan is to stand on the brief on the issues of contributory negligence and intervening negligence. I will do, unless there's specific questions, I'll do my best to address the rest of the issues. Because it involves a jurisdictional question, I do want to start with the issue of the general appearance and Dr. Rayna's appeal. Briefly, Your Honors, just to remind you, there is a pending motion to dismiss this appeal because the notice of appeal was not timely filed under the Slaughter case, and I'd just like to mention this is not rectified by Rule 28C of the Rules of Appellate Procedure. That allows for an alternate basis of law to support the order appealed from. And so the argument on the Slaughter is there was not a timely notice of appeal of this order.
Let's just briefly let's talk about Slaughter and the cross appeals here, since these are jurisdictional. Is it not true though in Slaughter, obviously a family law case, but indeed the case that Slaughter itself relied on, in both those instances you had parties appealing from what are effectively separate judgments, albeit from claims within a single lawsuit. Here we have one judgment that was entered in favor of the defendants, and it's merely a matter of picking out which of the interlocutory orders are going to be before it's on appeal. Isn't that a pretty big distinction here?
Your Honor, arguably so. However, the language of the court in Slaughter was very clear that on all interlocutory orders, that the notice of appeal from any order in the case, and this is a completely separate interlocutory order, not dealing with same issues in the final judgment. I read the language in Slaughter to be very clear that all appeals have to be given from separate orders within 30 days of when it becomes final, with the final judgment. And that's the way that I read the language of that opinion. But in any event, that issue, frankly, is of no real consequence either, because Judge Adams correctly decided that Dr. Rayna and his practice had made a general appearance in the case. Under GS 1-75.1, the court has personal jurisdiction over a defendant if they're served or if they make a general appearance in the case. Our court's opinions have been very clear that virtually anything other than a challenge to jurisdiction constitutes a general appearance. Here, of course, there was an answer filed, then a motion to tax cost, and then an amended answer which raises issues of jurisdiction and service for the very first time. Our cases have consistently held that virtually any motion, any court appearance constitutes a general appearance. In fact, before the amendment of 1-75.1, even getting an extension of time to answer was a general appearance. And of course, that specific part was changed by the legislature. Both parties cite Williams versus Williams. In that case, this court held that any appearance in any case, for any reason other than to challenge jurisdiction, the defendant thereby places himself in a situation as if he had been served. Now, the court said, of course, you're not impliedly making a general appearance if you just walk into the courtroom, if you have a conversation with the other party. And it cites the Fulton case for that principle. The Fulton case, which Dr. Rayna relies on very heavily, of course, specifically really involves general versus special appearances, which were eliminated when the rules of civil procedure were enacted. But in Fulton, essentially, you had a lawyer going to court and saying, Your Honor, I understand that this case is coming to hearing. If I appear, if I choose to, if I make an appearance in this case, can I get a continuance? But did not actually make any kind of appearance in the case. It was an inquiry. Now, in Williams, there was a court conference between the lawyer participated with in chambers with the judge and the party on the other side. Subsequent to that, an order was entered that had to be served as a result of that, following that conference. This court held that participating in that conference constituted a general appearance. In this case, Your Honors, Dr. Rayna is asking this court to create an exception for the general appearance rule, which does not exist under our case law.
So, Ms. Shields, part of the issue here is sort of the relation back, right? The effect of the filing the amended answer and the extent to which it sort of relates back and supersedes the initial answer. So, I mean, I guess one question I have is sort of hypothetically, if a defendant files an answer and fails to raise these Rule 12 defenses, particularly personal jurisdiction, CT before whatever, and then does that alone constitute a general appearance, notwithstanding their ability to file a second amended answer asserting those defenses that would otherwise relate back? And I see my lights are going off.
Yes, sir. Yes, Your Honor. And I'm happy to answer those questions. And frankly, I have 4 answers for that. The first is there's more than one way to waive jurisdiction. One is by not including it in your amended answer, right? If there had not been an intervening appearance, this would not be an issue. But there was. It was an intervening appearance. You can also waive it by general appearance, which is what happened here with the motion to text clause. Additionally, the purpose of Rule 15C is to avoid the bar by the passage of time of the statute of limitations. It does not undo affirmative acts that have been taken, and that's what happened here. Additionally, the language of 15C, and this gets back to its purpose, which is to deal with the statute of limitations, applies to claims. And I believe the federal rule says claims or defendants. Our rule says claims. And so that applies to claims by the plaintiff, cross claims, counterclaims, but doesn't apply to insert an otherwise waived, well, not waived, defense that has been waived by virtue of the general appearance. And finally, as Judge Adams found, here it would not relate back anyway because it doesn't arise out of the same transactions or occurrences. There's nothing in the original answer to give notice that this would be an issue. So by virtue of the general appearance on the motion to tax clause, service was not necessary on Dr. Reyna or on the practice. Your Honor, now I would like to switch to the Rule 9J issues. We have 2 different orders here. Judge Allen originally denied our motion to dismiss under 9J. Then Judge Hill allowed, yes, it was Harnett Health, yes, and Judge Hill allowed Dr. Reyna's 9J motion. Now, our Supreme Court recent decisions have been abundantly clear. 9J serves a gatekeeping function concerning the issue of pleading, not ultimate admissibility of testimony. Its purpose is to stop frivolous malpractice actions, and it does that by requiring review before a complaint is filed by a competent doctor. Now, the evidence is to be considered in the light most favorable to the plaintiff. There are multiple decisions of the Supreme Court on this in the last couple of years. Under the current rule, the complaint must certify that the medical care and all available and reasonably available medical records that pertain to the negligence, which is a key phrase, have been reviewed by someone reasonably expected. The test was to qualify under Rule 702. The rule, incidentally, does not require any kind of pre-suit review on the issue of causation. Now, Judge Hill found that certain medical records had not been reviewed. Briefly, Dr. Layer testified in his deposition that he had all the emergency medical evaluations records from March 8th and 9th. That's at page 8 of his transcript. He also received a large box of other records. Time of his deposition, he didn't remember when he got it, but that's put in the record. An affidavit prior, I believe it was prior to his deposition, page 173, he testified that he got those records before the very first complaint was filed. Now, he does testify that he did not extensively review the prior records, but that is not required. This court recently held that that's not required by Rule 9J in the case of Leonard versus Bell. All that has to be reviewed are the documents that are pertinent to the act of negligence, not even all the records pertinent to the condition, but to the acts of negligence alleged. And the court in Leonard versus Bell also observed or held that the question of what is pertinent or pertaining to the negligence is not a question for the court, it's a question for experts, and then ultimately, of course, the jury. Now, additionally, Judge Hill found that that 9J was appropriate because Dr. Layer, who's the reviewing expert, had not reviewed the notes that were written by Mrs. Miller. Those notes, Hilton versus Coons, we cite in the brief, just the previous version of 9J that talks about the definition of what's medical care, and those are things that are generated by physicians, not lay people. And we cite the medical legal guidelines definitions, which are agreed to between doctors and lawyers, and those are in the general rules of court. And I've heard a wise judge say, law says what it says and it means what it says. And in this case, the legislature specifically chose to say medical records. Obviously, the notes of a layperson are not medical records. If they were, reviewing experts would have to review diaries, notes, and potentially get well cards to be able to comply with the 9J standard. And that's simply not what's required here. Now, on reasonable, Judge Hill also found that it wasn't reasonably expected that Dr. Lair would qualify because he wasn't sufficiently familiar with workers' practice. Well, first of all, that's not required for the 9J review. This court's decided that. The case is cited in the brief, Roche versus Tennant. They can supplement later just as a Rule 702 expert. But in addition, this gets down to what the standard is under 702. Substantively, there's little real question, I think, that both of these experts did what they needed to do under 702. You can look at Parker versus Roseland in the Supreme Court case there. In that case, the expert knew the population of Goldsboro, it knew the level of care and facilities at Wayne County Hospital, and that was enough. And in this case, the affidavits of Dr. Lair on 267 to 324 of the record, and Dr. Harris, 196 to 252, they both knew the population of Harnett County, and they had an enormous amount of information about the facilities of Betsy Johnson at the very relevant time.
Ms. Shields, it seems like it seems one of the sort of the underlying themes of this case, both as it sort of relates specifically to 9J, but also as it relates to the exclusion of the expert witnesses, is trying to ascertain where the line is between, what is a question of admissibility, or what is the legal question of admissibility or compliance with Rule 9J on the one hand, versus what is really good fodder for cross-examination of those witnesses. What goes to the weight that should be given to those opinions as more as a jury question in this case. And this case seems to me to sort of, really kind of be asking that question. At what point is it in the trial court hands? At what point to go to the jury to determine that weight, which given that evidence? I'd like to hear from all the parties on this when it's your turn, but that seems to me the central theme. And so, can you articulate for me, how you think we should articulate that going forward?
And I can, Your Honor, and I will tell you, Judge Hill had defense lawyers in front of her that had developed very compelling arguments, but that's what they were. They are jury arguments. And in this particular instance, Judge Hill crossed that line and both decided issues of fact and issues of credibility. All of these issues, under the cases we cited in the brief, there was sufficient evidence to go to the jury. And that includes and you're right, both on when we get down to on the standard of care issue, on what they reviewed, all of these things under the cases, what was in the affidavits before the court was sufficient to create a jury issue. And frankly, that is also true on the issue of apparent agency. I'd like to talk about that for a minute. Under the Diggs versus Novant Health case, controls here on that. In this case, as I've mentioned before, and this is very important because it goes both to 9J and generally the qualifications of the experts as well. You remember I mentioned at the beginning, the allegations against the hospital are twofold: the negligence of the nurses, but also the negligence of Dr. Rayna. And there was in the complaint, we're basing this on apparent agency. There is no question that Dr. Lair, the Rule 9J expert, gave testimony on the standard of care by Dr. Rayna. No question about that. And so under Diggs versus Novant Health, and that creates the standard, the hospital holds itself out as holding medical services, and the patient looks to the hospital for care rather than to the individual physician, and accepted care based on a reasonable belief. And then it creates a jury issue on apparent agency, and the hospital can avoid liability by giving what the court called meaningful notice to the patient, and that is the issue in most of the cases. This case is unique. Factually, this case is unique. In this particular case, Harnett Health testified in a 30B6 deposition and was asked, what do you do to give notice to the patients? And they said, we do two things. We have signage and we have consent forms. Now, on the signage, the signs that were in existence in 2010 were no longer available, and Harnett Health testified it didn't know the exact location, the exact sign, the exact wording of those signs. What it did know is that it had changed since 2010 to make sure that people could see them. And Mrs. Miller, in her affidavit, said, I've been to Betsy Johnson before. I've never seen any of those signs, and I didn't see signs on the day of admission in March of 2010. So the evidence is that whatever the signs were, whether they were there, whatever they said, the Millers didn't know about them. But also, the other thing that the hospital does to give notice is to have consent forms to be signed by the patients. And in this case, there is no dispute. That consent form is at record page 628. And while the hospital argues, well, that was part of Mr. Miller's file, it's true. It was put into Mr. Miller's patient file in his records. But what that form shows is that Mr. Miller did not sign it. The note says, patient unable to sign. So Mrs. Miller's testimony that we never saw this consent form is undisputed. And we've argued in our brief on that would have justified summary judgment for the Millers on the issue of apparent agency. But at a minimum, it creates a jury issue on apparent agency for the jury to decide. So because of that, regardless of whether Dr. Layer's testimony was on the nurses was reasonably expected from the plaintiff's perspective, the fact that Dr. Layer testified that that Dr. Rayna violated the standard of care, and the fact that there's evidence to support this apparent agent theory means that there was an adequate 9J certification. Now, I'll talk briefly about the nurses and the reasonable expectation, and that's set out in the brief.
Ms. Shields, before we move on from the summary judgment, generally apparent agency question, understanding where we review summary judgment de novo, but just for context here, what was the rationale for the grant of summary judgment by the trial court in this case? You might
on apparent agency.
Well, no, I mean just generally. My sense is it was more based on the fact that since the expert witnesses were excluded, you could not make your case at summary judgment.
That is my assumption and understanding too, Your Honor, and that everything was frankly just put into the order. I mean, including on damages, and obviously there's evidence of damage to go to the jury. The order itself looks kind of like a check the box. But I don't mean that to sound disrespectful. I don't mean that to sound disrespectful. But the meaty issue had to do with the sufficiency of the expert testimony.
Well, it would seem if you had no expert testimony to support your medical malpractice case, then of course you couldn't establish a breach of duty. You could not establish proximate cause, and then in turn you could not establish damages.
Exactly. And the experts, and briefly, the experts were basically excluded on demographic information and the failure to review the records. I'll stand on the brief on that. There is nothing under Rule 7 that requires particular records to be reviewed. With regard to the training of the nurses, also just briefly, Rule 702B, there's a different standard for a doctor to be able to testify about nurses than doctors. This meets Dr. Harris's testimony meets that standard under Rule 702B. And I just point the court to the case of Feeney versus Alexander, which was cited both by Harnett Health and by us. about what's required of a doctor on reviewing nursing care. And Dr. Harris, in his testimony, his evidence, I worked at a hospital similar to Betsy Johnson at the relevant time. I had worked with over 1 million nurses in my career. I know the standard of care. Under the Haney case, that's adequate. Your Honor, with my minute and a half, I would like to talk very briefly about proximate cause, because that was another basis that's at least stated in the order. There is substantial evidence of proximate cause in this case. Generally, it is basically the failure to assess Mr. Miller's condition on either admission to the hospital. And the doctor gives many examples of that, but that's fundamentally what happened is the basic assessment was not done on the first admission. If it had been done, he would not have been discharged. His condition would have been recognized, a very serious condition that it was, and he would have lived. When he came back to the hospital on the night, again, failure to assess, failure to treat, failure to give him either oxygen or IV fluid, which either of the nurses or the doctors could have done. And he would have survived had he had those treatments. All of these failures, Dr. Harris attributes to the nurses and Dr. Rayner, but I want to talk for a minute about the fact that he attributes all of them to Dr. Rayner. Because of the apparent agency issue, those failures on Dr. Rayner's part means that Dr. Rayner is liable, as are his principals. That would include both his practice and Harnett Health would be liable for his omissions. And because there's sufficient evidence to go to the jury on apparent agency, there's certainly enough on proximate cause. But in any event, even if the liability of Harnett Health is based solely on the negligence of the nurses, Dr. Harris did set out their failures to assess. Essentially, his overall conclusion was, this patient was not cared for. I wouldn't go so far as to say ignored, but that's more or less what his conclusion was. Everyone disregarded his condition. No one did the proper assessments. No one gave the treatments, particularly when he came back on the night. Anyone could have given him those IV fluids, the doctors or the nurses, and he would have survived. And so this was enough to go to the jury on the issue of proximate cause. And Your Honor, with that, I would like to reserve my 4 minutes and 9 seconds for rebuttal.
Great. Unless there are any other questions from the panel, we'll reserve you a little over 4 minutes for rebuttal. Okay. Ms. Wood, if you're ready to proceed, we'll hear from the appellees. Just a reminder to kind of keep your all's on time.
Yes, Your Honor. Thank you so much. And may it please the court. Again, my name is Maria Wood. I have the honor and pleasure of representing Harnett Health Systems, which does business as Betsy Johnson Memorial Hospital in this case and with respect to these appeals. And again, my profuse apologies to the court and to the attorneys for our technical issues this morning. Thank you for your patience. I will now jump into my arguments, which will address both our cross appeal from the trial court's denial of our Rule 9J motion as to Dr. Lair, and I will also respond to the plaintiff appellant's arguments in which they seek reversal of the summary judgment order dismissing the case against the defendants. Turning first to my Rule 9J motion to dismiss, I'm going to highlight the facts as they relate to plaintiff appellant's Rule 9 or plaintiff appellee in this situation, Rule 9J expert and the information he had and how his testimony and how our motion to dismiss transpired, because we do believe that the trial court erred in denying our motion in October of 2015.
Wood, let me stop there. Just just speaking just facially on the face of the complaint and understanding your argument, would you agree that as a matter just facially reading the complaint, that the plaintiff here, the allegations themselves at least comply with Rule 9J?
Yes, Your Honor. The complaint facially complied with Rule 9J. And to add to that, or I'm sorry, did you have another question, Your Honor?
Well, I guess just sort of following on. So then the issue becomes this, sort of the discovery and that sort of thing that happens, and certainly is sort of become adopted practice is, to allow defendants to kind of attack that 9J certification based on the actual facts. So is it not? So in some sense, your arguments are all kind of tied up as it relates to the exclusion of Dr. Lair and summary judgment in your client's favor as it relates to the 9J. It's based on information that was discovered through the course of litigation.
I'm not sure I'm understanding your question, Your Honor.
I guess just from a chronological standpoint, you make the motion to dismiss based on failure to comply with Rule 9J in October and 2015. At that point, you got essentially the facial acknowledgement in the complaint. It's really only in Dr. Lair's deposition, I guess, that it comes to light that he's not actually offering specific criticisms as to Harnett Health and the nursing staff in particular. That seems to me to go more to what was ultimately your successful summary judgment argument, your successful motion to exclude him as an expert witness. So I guess the question is there really any difference here as to whether we're reviewing the denial of the 9J motion in 2015 or the summary judgment in order to exclude the witnesses in 2019?
We do, there is a difference. We do contend strongly that Dr. Lair, that our motion to dismiss under Rule 9J should have been granted just based on the rules and the requirements of Rule 9J. And the case law establishes that even if a complaint facially complies with Rule 9J, if subsequent discovery reveals noncompliance, then Rule 9J can be used as an avenue to seek dismissal of the case. And Rule 9J essentially has two requirements. Rule 9J1 requires that the witness have a willingness to testify. And number two, Rule 9J requires that that witness be reasonably expected to qualify as an expert. And in that regard, the deposition testimony is clear. Dr. Lair was never willing to testify against Betsy Johnson, against Harnett Health. It was unambiguous in terms of his willingness. And the second prong involves whether he was reasonably expected to qualify, and that's a little more complicated. And in Dr. Lair's case, there were three affidavits that were presented, on two from him and one from plaintiff's counsel in an attempt to defeat our Rule 9J motion. And I do want to explain why we do not believe that those affidavits established a willingness to testify or established any sort of reasonable expectation that this expert would be qualified to testify. The initial affidavit from Dr. Lair, which was submitted prior to his deposition occurred in May of 2015. There's affidavit number 1, in which he very generally states that he had been contacted by plaintiff and had rendered opinions against the defendants in the manner set out in the complaint. The affidavit is no more specific than that. 3 days before his deposition, which would have been his deposition was on May 29th, and 3 days before his deposition, he submitted another affidavit, which was dated May 26th, 2015. And that affidavit is very detailed and discusses it purports to establish his familiarity with the standard of care and with the co-defendant, Dr. Reyna. But nowhere in that affidavit does he mention any sort of familiarity or any sort of specific opinions or any mention of the co-defendant Harnett Health. Fast forward to his deposition, and he's asked questions in that regard, and he answers right out of the gate that no, I have never been critical of Harnett Health. And then moving a step further to the reasonable expectation issue, he also acknowledges, and in fact, he volunteered this. This was not even in response to a question. He volunteers in his testimony that he is not an emergency nursing expert. And that is an unambiguous black and white assertion that I'm not an emergency nursing expert, which translates into he does not qualify. Now, going the next step to the reasonable expectation of qualification, following the deposition, we filed our Rule 9J motion. And I believe the day of the hearing, we received not an affidavit from Dr. Lair, but an affidavit from plaintiff's counsel asserting that he had spoken with Dr. Lair prior to initially filing the case in 2011, that he had spoken with him and assured himself that Dr. Lair, that he reasonably expected that Dr. Lair would qualify. We urged that affidavit not be considered because with Dr. Lair's testimony that he had never been critical of Harnett Health, he thus never was willing to testify, which is a component of the Rule 9J statute. So for those reasons, we do respectfully request that the trial court's order denying our Rule 9J motion to dismiss, which we filed in 2015, far years ahead of these other motions that we're talking about today. We respectfully request that order be reversed.
Will you discuss a little bit the argument on apparent agency, and how, from your perspective, that applies or does not apply to this case? If in fact Dr. Lair qualifies as an expert critical of Dr. Reyna, that via allegations of apparent agency extends to the hospital.
We in terms of the apparent agency, I acknowledge the Diggs case. I acknowledge the various factors that need to be used in determining whether somebody could be considered an apparent agency of a corporation such as a hospital. But again, resubmit the arguments that we made at the trial court level, that there was testimony that there were signs. There is a consent form contained in Mr. Miller's medical records, specifically notifying him that emergency physicians and other specialty type physicians are not employed by the hospital. And for those reasons, we believe that the trial court properly found that there was no apparent agency as to Harnett Health with respect to Dr. Reyna in this case.
Ms. Wood, as it relates to the notice that was given at the hospital, if I recall, it indicated that the patient was unable to sign. So is it the hospital's position that because it was placed in the medical record, and based on my review of the record, there's no evidence that the patient actually ever saw it, it was just placed in the medical record? Is that sort of where you hang in your argument on there?
He was unable. That is correct, Your Honor. He was unable to sign the form, and that's documented in the record itself. But yes, that is part of the argument, that he was given this form. He and his wife were given this form when they were at the hospital, and it informed them that Dr. Reyna was not employed by the hospital. But even if though this court were to reverse the trial court's ruling as to granting summary, as to the apparent agency, my apologies, we still believe that the summary judgment order dismissing the case should stand because as we articulated, and I'm beginning to run out of time, so I will just briefly review this and largely for the remainder rely on our briefs. But even if there were to be a parent agency of Dr. Reyna or of the hospital for Dr. Reyna's actions, neither expert that the plaintiff designated qualified to testify at the trial. Plaintiff only had two experts. One was Dr. Lair, and the other one was a Dr. Gary B. Harris. Now, I won't rehash the arguments as to Dr. Lair. We reasserted them again as a motion to exclude in front of the trial judge, and she excluded him. But with respect to Dr. Harris, I will highlight his deposition testimony to us that he was not familiar and did not know who from Harnett Health he was critical of. There's a plethora of case law in discussing Rule 702, which points out that part of the requirement of Rule 702 and part of the requirement of familiarity is that the expert be familiar with the defendant's training, education, and background. That is discussed in the Katie versus Caprioli case, the Haney versus Alexander case, Henry versus Southeastern OBGYN case, and many more that are cited in our briefs, that the individual who wants to testify as a standard of care expert on behalf of the defendant needs to know about that defendant. So I asked Dr. Harris in his deposition who he was critical of at Harnett Health and what he knew about those individuals. And Dr. Harris didn't even know who he was critical of. He had to sit there and review the records and attempt to identify individuals. And when he did so, he identified several nurses, and he also actually identified the plaintiff, Mrs. Miller's sister, as a nurse at Harnett Health.
But is that the actual specific requirement that an expert critical of the nursing care that a patient will receive? Obviously, this is in Harnett County, but even at a massive hospital system, be required to specifically identify by name every single nurse or other practitioner that they're critical of. That they're able to, identify recite the CV of every single person that's involved in a general, allegation of negligence against the hospital system. Is that the requirement, or is it the requirement more that they be familiar with the types of training and experience, as well as the standard of care in that community or similar community?
Your Honor, I see that I'm out of time. May I briefly respond to your question? Okay, thank you. Whether the rules and the rule in the case law don't specifically require, for example, as you mentioned, an expert to go through and be able to name every single nurse in the hospital who saw them. However, information like that can be used to evaluate whether the expert is familiar with the defendant's training, education, and background. And when I went on to ask Dr. Harris, what do you know about these nurses? What do you know about their training, education, and background? He knew nothing. He briefly referenced JACO, but then clarified that was not the standard of care that he was applying. So no, they don't have to specifically know, but that is part of an analysis and trying to determine whether they are familiar as required by Rule 702. And I see that my time is now up unless there are further questions from the court. Thank you.
Mr. Foy, we'll give you an extra minute or so as needed.
Thank you, Your Honor. May it please the court. Again, it is my honor as well to be in front of the Court of Appeals today. And I, along with my colleagues, I would join in thanking you for allowing us the opportunity to make argument today. We do appreciate that. I think I'll start out. I know I'm fairly limited in my time, and there is an abundance of material to discuss. So I think I'm going to start with the Rule 9J motion to dismiss, because I believe there are some aspects of that I can discuss that dovetail into the motions to exclude with regard to 702, 90-2112. So I'll start with 9J. So as Your Honor pointed out, I think earlier in the arguments, that in fact, the original filing of this case was filed 1 day prior to the new 9J going into effect pursuant to tort reform. There's been some discussion here today about which one applies. You know, from our perspective, you can apply either the pre-2011 9J or the post-2011 9J. We believe that no matter which one is applied, we would prevail, and Judge Hill's order on 9J should be upheld. If you look at the pre-2011, it talks about you've got to review the medical care. Okay, it doesn't limit it to medical records. Now, if we just look at that, it is apparent from Dr. Layer's deposition that he did not review all of the relevant medical care. Okay, to wit, it is apparent from the record, despite plaintiff's assertions to the contrary, that he did not review the EMT records from March 8th of 2010. Now, remember, based on the facts, the patient was transported by EMT to the emergency department on March 8th and also transported by EMTs on March 10th of 2010. Now, that is important. Actually, excuse me, March 9th, 2010. That is important because those EMT records do reflect the condition of the patient on the day at issue, care that was given to him on the day at issue. And it certainly is evidence that Judge Hill could use to determine that indeed the March 8 EMT records are pertinent medical records to the case, number one, and do reflect medical care given to this patient that is important for an expert to use in determining whether or not they believe there was any negligence on that day. Because as we know, an expert not only has to prove that there was a breach in the standard of care, they have to prove causation as well. And so those things that are in those EMT records, the data, the facts, the information that are in those EMT records on March 8 are important, as Judge Hill determined. Now,
so Mr. Foy, I actually have sort of two questions. One kind of backing up as to which statute applies. Are you contending that the prior standard of reviewing medical care is somehow more of a stringent standard than under the requirement to review all the pertinent medical records?
No, Your Honor. In fact, I'm saying if you look at the term medical care, it's broader than just limiting it to medical records. So I think it's a broader interpretation of what can fall under medical care and what is important for an expert witness to review. And so, Your Honor, and Ms. Shields said this in her opening remarks. She said all pertinent medical records were reviewed. And in fact, if you look at their briefs repeatedly, they state, for example, on page 21 of their brief, they state, defendant did not demonstrate that Dr. Layer did not review EMT records. And they go on to say that on page 22, there is no suggestion anywhere in the record that the review of prior medical records did not occur before plaintiff filed the present action on 6 February 2014.
And that brings me to my second question, which is this concept of, let's talk about like what's pertinent record. What is term pertinent? That seems very much sort of in the eye of the beholder. If the expert believes that they've reviewed the records that were in fact pertinent, I guess obviously it's great fodder for cross-examination, great fodder for jury argument. But it kind of goes to this question: at what point are we talking about questions of purely of admissibility, this legal question? At what point are we talking about factual arguments for the jury? At what point, is the trial court engaging here in a fact-finding exercise that's better left to the jury?
I agree, Your Honor. So there has to be a line somewhere. And so these gatekeeping statutes, whether you're looking at 702, 9J, or 90-2112, these gatekeeping statutes give that discretion to the trial judge to help determine what is pertinent, what would be considered relevant to the medical care. it's the trial court that has to make that determination per law to make sure that the information that the expert reviewed is sufficiently reliable, that it can go in front of a jury. And so let me focus your honors back for a minute on what I was getting ready to get into, and that is where the plaintiff repeatedly says that there's no evidence that Dr. Layer did not review the March 8, 2010 EMT records. Well, there is plenty of evidence that he did not have those records, therefore he could not have reviewed them. To wit, let's look at the first affidavit of Dr. Layer. He sets forth the medical records in that affidavit that he reviewed. At no point does he mention any EMT records. Okay.
So, for example, what do we have in the record from defendants experts saying that a failure to review these EMT records is a failure to review all the pertinent records or a failure to review the medical care? Where's the evidence on that?
That's not a necessary determination by the trial court in determining whether or not this particular plaintiff's expert witness pursuant to 9J had the necessary information that was sufficiently reliable to allow them to apply their technique of review, right? So that's not an issue for the trial court. What I think is important here is that the plaintiff does repeatedly state that there's no evidence that Dr. Layer did not have these records. There is evidence he did not have these records. Number one, it's in his affidavit. He does not list them in his affidavit, so he did not have them at that time.
Mr. Ford, let me interrupt you just a second, and I'll be brief. I don't want to steal a lot of your time. But isn't it highly likely that the EMT records were incorporated into the ER records at the time of admission?
No, Your Honor, they were not actually. In fact, we never had the EMT records until 2019, despite the fact that we had issued requests for production of documents going back to the first complaint, which actually I don't think were ever responded to. But after we filed them in the second lawsuit, we never received any EMT records from the plaintiff. In fact, and we talked about this with Judge Hill at the hearing, we had to get a release sign from the plaintiff, and we received those records. Actually, Ms. Woods wrote to the medical records custodian at Dunn Emergency Services on March 8, 2019, with the release requesting those records, and they were provided later that month. So the plaintiff actually never even had the EMT records from that first EMT. We didn't even know there was that the EMTs took the patient to the hospital on March 8th until we got the handwritten notes in 2018 from Mrs. Ennis, who was then Mrs. Miller. We got those notes, and for the first time, we learned that, in fact, the patient was transported. Those records were not in the hospital record.
My understanding is Dr. Reyna treated both days. Is that not correct?
That is correct, Your Honor.
And your position is that you didn't know he came in on the 8th, even though Dr. Reyna was the treating physician on the 8th.
Well, Dr. Reyna is not the one who receives the patient.
Okay. And to take that a little further, the position that you're taking on behalf of Dr. Rainey is EMS pulls up, drops off the patient, doesn't say a word, keeps all their paperwork, and says, here it is, it's your opportunity to do what you do, Doc.
Well, those EMTs have not been deposed, and the front desk personnel have not been deposed at the hospital, so I don't know what happened factually. But what I think is important here is that there was sound evidence for Judge Hill to determine that Dr. Layer, as the 9J, did not review all the medical care and did not review all the pertinent medical records, whether you're looking at the prior statute or the post statute. And the post statute really incorporates both. But I think that's the important thing here, is that Judge Hill determined that these March 8 records contained information that an expert needed, along with the handwritten notes. We also discussed with Judge Hill that, like, for instance, Dr. Harris, well, I'll get into that in a minute. I know I'm running out of time here. But what I think is important here, Your Honor, is that there was competent evidence to determine that Dr. Layer did not review all the medical care, or not even all the medical care, did not review pertinent medical care in this case, whether you're looking at the old or the new statute, that was necessary and could be outcome determinative to this. And this is something that plaintiff also brought up in her brief, and that is when you're looking at what an expert needs to review, they don't have to review all the medical records, but they do have to review pertinent medical records. And I will flip this back on the plaintiff and say there's no evidence that the March 8 records are not pertinent. And I'll also going back and talk about some things that Dr. Layer testified in his deposition, because there are assertions all throughout the plaintiff's brief where they talk about Dr. Layer did review all the prior medical records. That's just not accurate. Page 8, he testifies that the first email he received included only the ED records from March 8 and March 9. He later received a large box of records. He did not review those records in detail, he testified. He only reviewed some limited lab values. That's all he looked at. He looked at no other records. He did not look at the patient's prior cardiac records, which is what Judge Hill was referring when she says in her order that he did not review all prior medical records that she believed were pertinent, because this patient had underlying heart conditions. And if you go back and look at the depositions testimony of Dr. Layer and Dr. Harris, they make cardiac conditions an issue. So they make it an issue. Again, the EMT record from March 8 was only obtained in 2018. Your Honor, I would also point out, you had talked about where do we draw the line in trying to determine, does the expert have sufficient information, right? So there's obviously a line somewhere, and whether or not they're qualified to render that opinion based on the information of that medical community. And so we would agree that an expert does not have to make a determination on whether or not a defendant did or did not violate the standard of care based on their own personal knowledge of that community, right? They can gain that knowledge through reviewing information that gives them the information to determine, okay, although I don't practice in that medical community, I practice in a similar medical community, or I'm familiar with a similar medical community, I can compare it to the medical community at issue. Now, that's important in this case as to Dr. Layer and Dr. Harris, and this is where there's some overlap, dovetailing into 702 and 90-2112, and that is, Your Honor, when you look at the affidavit that they signed that attaches, and this is the plaintiff's own evidence, and that attaches the demographics. And Dr. Layer testified as the 9J that he became familiar with the medical community for Dr. Reyna and the hospital by reviewing the demographics only. He testified in his deposition that that was all he was basing his information on the Dunn medical community, was based solely on what was in the demographic information. And Your Honor, in black and white, when you pull out that information, as Judge Hill noted in her order, it is from April 2015. That's what it's dated. And it does have a few stats that relate back to 2010, but the vast majority are from 2013 forward. Not only that, they point to the 2010 hospital license renewal application. Well, it's important, Your Honor, the devil's in the details. When you look at that facility data information, it states the reporting period for that. All responses, and this is a quote from the 2010 application, all responses should pertain to the period October 1, 2008 to September 30, 2009. That's only a 6-month overlap. That doesn't include that entire year period prior to the events at issue, which is what the experts have to look at. So whether or not Dr. Layer had to sufficiently familiarize himself with the medical community prior to rendering a 9J opinion, if we look at what information he acquired, the only information he acquired about that community, it is not sufficient to allow him to testify in this case against Dr. Reyna or the hospital, because the data that he had does not reflect that year period immediately prior to the period. It doesn't reflect that year. And there's case law that we've cited in our briefs that demonstrate that.
Good. And Mr. Floyd, we'll give you a few seconds to wrap up.
Okay, Your Honor, I wanted to get into a little bit more, I'm sorry, about the plaintiff's statements. As you can see from the records, we did not find out about her handwritten notes until later. Judge Hill says they materially changed the facts. And I would point out too, in her order, she's not saying, I believe these facts. You know, she's not making a qualitative opinion about the facts. She's not saying I do or don't believe it. She's saying, wait a minute, these facts are materially different than what the plaintiff has said for the past 7, 8 years, 9 years. And so I believe that would be important information that an expert would have to have before they render the opinion. Now,
thank you, Mr. Floyd.
Okay.
Appreciate it. Ms. Shields, rebuttal.
Thank you, Your Honor. I will start with the arguments made by Ms. Wood with regard to Dr. Layer and whether there was a reasonable expectation that he was willing to testify. I point the court to record page 173, verification of the Rule 9J discovery interrogatory time by Dr. Layer. He specifically testified that prior to the filing of the previous action, he reviewed the medical care of the decedent and was willing and prepared to give testimony against Harnett Health System, UVA Betsy Johnson Hospital. He also says that he was willing to testify as alleged in the complaint, allegations alleged in the complaint, and the affidavit that appears in 173 and 174 of the record. So he did tell, and Mr. Adams in his affidavit, and I won't go into the details, he did tell Mr. Adams that he was willing to testify. Mr. Adams understood that that's what he had to find out from that witness. On the issue of current agency, I cannot read my notes, so that's not good. On the issue raised, Judge Hampson, about the familiarity of the training of the nurses, I'd like to go back. I mentioned this briefly in my opening. I'd like to go back and talk about that now. As I'd mentioned before, we're 702D, a very different standard for providing testimony concerning nurses. All 702D requires is the doctor, by reason of active clinical practice or instruction, has knowledge of the applicable standard of care of the nurses. And in the Haney versus Alexander case, that standard was applied. An affidavit testimony that is very similar to the affidavit here was presented, and that was considered sufficient. It's not addressed in the briefs, and no one's addressed it today, but Dr. Harris gave an affidavit that begins at page 427 of the record that explains in great detail why he is confident that he knows the applicable standard of care for nurses similar to those in Betsy Johnson Memorial Hospital. And as Your Honor pointed out, there are no cases that I have been able to locate, and no cases that have been cited by either of the defendants that says that the testifying expert has to have knowledge of the individual training of individual nurses. And I'd also like to point out that the nurses are not defendants here. It's the hospital that's the defendant. And so his testimony was adequate under Rule 702. With regard to Dr. Harris and the records, I'd like to point out that Carpenter raised this question: could Dr. Harris have been referring to the Betsy Johnson records in his affidavit and the testimony that no one knew that was arrived by ambulance? The Rhonda deposition exhibit 1 shows that the Harnett Health record shows that he had arrived by ambulance. So everyone did know he had arrived by ambulance, and as pointed out in my brief, he testifies, Dr. Harris testifies as to information that he obtained from those EMT records. In addition to that, I'd like to talk for just a minute about the Leonard versus Bell case that I mentioned. I'm familiar with it. I didn't work on it, but my law firm lost that case. And so I'm very aware of that case. And it talks about what is a pertinent medical record. In that particular case, the plaintiff was a prisoner who had been provided medical care by prison physicians and had been incarcerated for a long period of time. He had went to Dr. Bell and another doctor for over a period of about 10 months to a year complaining of back pain. As it turns out, that back pain was caused by the fact that he had tuberculosis. What the reviewing doctor had not seen is prior records concerning his earlier test positive for tuberculosis. What this court held was that you do not have to see all the records concerning the underlying condition. You have to see records concerning the pertinent care. And as Judge Hanson pointed out, that is for the expert to say. In Dr. Harris's testimony, in his deposition, he said, I have seen all the records I need to see to render my opinion. And bear in mind that what both Dr. Harris and Dr. Lay are looking at is what is the emergency room physician seeing. That's who I am offering an opinion on. They saw the records that Dr. Reyna saw.
And Ms. Shields, we'll give you just a few seconds to conclude.
Yes. So Dr. Harris is essentially this. When ending with the idea of where do you draw the line, the Supreme Court has said, I'll tell you where you draw the line. You draw the line in favor of the plaintiff. You look at all of the evidence in the light most favorable to the plaintiff. And that is where the Superior Court erred here. In addition to deciding issues of fact and issues of credibility, the evidence here was not looked at in favor of the plaintiff. All of these motions for summary judgment should have been denied. The 9J motions, one was properly denied, the other should have been denied. There was sufficient evidence to meet the standard on all the cases that we cited to the court. Thank you for your time.
Thank you, Ms. Shields. I'd like to thank all the parties for the excellent arguments this morning. All very helpful and informative, and we really appreciate it. And with that, the case will be submitted. Mr. Sword, if you can close court, please.
This session of the North Carolina Court of Appeals is now adjourned.
Thank you all.
Thank you.
Thank you.